is the attorney. I send some stuff to. I always send tenants who call me. I end up sometimes sending them tenants on my cases. I don't know it because if they're a tenant, I don't listen to them. I send them to Nick. But also, he's been a resource for me and my clients. He's been getting creative during, but not to do with the CDC, but going after other means to get people out, going into circuit court instead of associate, and doing a what's it called, a TRO.
441.
Give them an idea of what you've been doing. Luke is with the Pacific Legal Foundation going after the CDC. We're going to have to speak here in a moment, but
I think Luke and I talked on the first call, but yeah, no, we're filing 441s,
right.
Basically TROs saying they're damaging the property or they're a threat to landlords, and that they can't stay due to the constitutional property issues. And so far we've been about 8 out of 8 on that, with the sheriffs actually doing executions, including what I would say, and Matt would probably agree, the most liberal judge in the city, Judge Perkins, is finally granted one on Monday for a guy that was shoving socks down the toilet, messing with the stacks and the plumbing, causing tens of thousands of dollars worth of damage. Because Matt had evicted
for a landlord, that's not the easiest guy to deal with.
No, and Matt had evicted the guy, so he knows he's at the end of his rope here, and he's gonna get booted. So he's just like, okay, let's have some fun. And the landlord testified very credibly as to the damages, and Perkins ordered him out within, I think, 3 days, and then continued. Technically, under the 441, you only get 15 days, but Perkins gave him 45, which is when our next court date is. And just like, you can't go back until after we figure this all out.
That is
it's crazy.
Right? Yeah, I'm hearing all sorts of creative things. I just was talking to someone here a moment ago who told me he's actually bringing, while the judges are in that state are just categorically not allowing these evictions to go forward once the declaration is completed, he's actually hiring a court reporter to come into the justice of the peace to to have a record so that he can turn that over to the U.S. District Attorney's Office to prosecute for perjury.
Well, I've asked for several times, and I got one on today. I'm actually on a docket right now while he's doing his talking, that he's denying. So I get service on somebody, rent possession or a debt case, and he says that since it's the first time, they get a continuance, which is that's not how this works in Missouri. If you get served, you don't show up, you get defaulted. So today I have 6 of them. So I filed a whole bunch of requests for findings of fact and conclusions of law as to the denial of the default, because he refuses to put it on the record why he's denying it. And now, worse, the other 2 judges that sit across the hall from him hear the same cases. They're granting the defaults on the first time. And now this judge just is not – I don't even want to say he's playing by the rules, because he's making up his own rules as he goes.
Yeah.
So we'll see.
All right. So, and I'm posting on the Facebook Live. All right. So what do we got here? Preparing live stream view. Who do we got? We got a bunch of people coming on. We got people from all over. I think this is not the first time I've had somebody from way out of the country. We got Issam here logging in from Iraq. Hello. Good morning. Robert Fraga. Who is Robert? Which Robert is this?
That's me. Terraview.
Oh, Terraview. Okay. Gotcha. Okay. And we've got.
I cut my hair. That's why you probably didn't recognize him.
Yeah. I think we've spoken, over Zoom once before. So, we got Jamie Bryan. We got Sarah Elizabeth, of course, from Pavilion. Okay. We've got a whole bunch of people. We're going to get a few more. I don't know why this Facebook Live is kind of like hung up. Go live on Facebook. It's just kind of hanging. Okay. Can anybody tell me why Facebook sucks so badly? There's got to be a good reason for it. Maybe it's because Mark Zuckerberg's such a douchebag. I don't know. Try this again. Go live. Oh, it says it's on. Oh, stop live stream. No. Okay. So it appears to be on. Let me, maybe it just didn't kind of load. Could somebody just look on the Facebook and see if it appears to be live right now? Tell me if it is. All right. Is anybody able to hop on their Facebook and see if I'm live streaming, please? Kindly. We got a few more people here. I wish I could disable the ding on my, how do I disable that damn ding? Messaging, hold on. Preferences, because that just keeps dinging the whole time. Play sound effects. Let's do no. Okay, maybe that'll work. All right. All right, folks, we're going to get started here. Everybody is waiting patiently. Is anybody able to tell me if I'm live streaming onto the Facebook? Please. Zoom seems to think I am, because it's the only option I get is stop the live stream, but I'm not sure if it is. No, I don't see it from Jamie. Okay, so let's stop it and restart it. Stop. Live on Facebook. Let's try it again. Post on my timeline. Share on the timeline. It's preparing. I got this far last time, but then it just kind of hung. I fully believe that it is because Mark Zuckerberg is a terrible person. The company is a terrible company. But we all use it, and it's not happening. Well, I'm recording this, so if it doesn't work, I can always post it later. All righty, folks. So, still preparing. Maybe it'll start. Anyhow, we've got with us a special guest on the Chase Law thing. And everybody, Jamie, I guess is just picking up background noise with you. If you could mute, please. That would be awesome. And there we go. And we got Dave Howell. Good morning. All right. So, Luke, if you would, I wanted to, I've been telling some of you how are we dealing with this CDC moratorium? I'm going to give you kind of a brief summary of what I'd like to cover today. It's a lot of the same, just a little bit more updated, but what we've got going on is as follows. We've got the CDC moratorium. Well, more on that in a moment. We've got the delays with the courts still ongoing. Delays are crazy. We have been somewhat catching up with the courts. I had a long meeting with Joan Gilmer, who is the circuit clerk, the clerk, and I'll get into it in more detail. They're starting to get their act together. I think we're seeing kind of craziness. I mean, a couple of pro se cases are being processed lightning fast, and bulk filers like me are taking a longer time. And we got Nick Metters nodding his head. I mean, it's crazy how far behind they are still. They claim, well, everybody's at home and blah, 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 blah. Whatever. We'll get to that in more detail. Second thing is sheriffs, still closed. More on that in a bit. Third thing is Nick Metter. He's been here before. He's going to be talking as well after Luke. So Luke is up really early. He's in the People's Republic of California. Unfortunately for him, he lives in a state that does not allow evictions, I think, in the best of times. I don't know why he would be there. Of course, it is a beautiful state. The scenery is awesome. The people are stoned. I think all of them, most of the time, most of them all of the time. I'm not sure. But it is a beautiful place with beautiful beaches, beautiful mountains. You can ski, snow ski, and surf on the same day in that state. You cannot surf in Missouri anywhere, I don't think. But it's run by communists. Nevertheless, apparently started on the Reagan Ranch is a company called Pacific Legal Foundation. Because it started on the Reagan Ranch, obviously it is a liberal institution. No. his law firm has many attorneys, and they've had a bunch of Supreme Court cases, some wins, a lot of wins at the Supreme Court level, and they are focused generally as a firm on property rights. This time they are looking at the CDC pronouncement, the CDC power grab. That is what it is. I'm going to turn it over to him. Let you know what he's doing. How does it impact us here in Missouri? So far, we don't know. There might be involvement with the Chase law firm, with some of our clients, one or two of our clients. But Luke, I'm going to turn it over to you for a moment, sir.
Yeah, thanks, Chase. Happy to talk for a second. And Pacific Legal Foundation has won 12 cases in the U.S. Supreme Court. We have a long track record defending property rights. And in this case, we're looking to sue CDC. We have, we reached out to Matthew because we saw him as one of the leading eviction attorneys in the St. Louis area, and wanted to talk with him as we were looking throughout the country to find, plaintiffs to get this CDC accountable. There is currently one lawsuit in the Northern District of Georgia, but we are planning to launch our own lawsuit here very shortly, and possibly a second after that, after we get the first one out the door. And so it will be somewhere in the United States. We probably in Louisiana actually is our first case, but it's yet to be filed. And we've got a very sympathetic story there, a landlord who really is in a very difficult bind. She cannot even pay her own mortgage. She just has one condo that she rents out, but she can't pay her mortgage or afford other necessities because her tenant is not paying, and she can't evict because of the CDC moratorium. So we're looking to launch this suit here actually within the next day or two, and we're going to immediately pursue a preliminary and when you file that sort of motion, you're asking the court to move very quickly to block the enforcement of the rule that you're challenging. And we've got several grounds for arguing that CDC's rule is illegal. It's unconstitutional. They lack statutory authority to do what they're trying to do. And even if they had statutory authority, even if they could constitutionally do what they're trying to do, they violated federal law in doing it without even giving the public an opportunity, landlords like the folks on this call, an opportunity to raise concerns and what we call a notice and comment process. So there's a lot of infirmities here. We think that we've got very strong grounds to actually invalidate the rule. Now, the challenge is, though, that the order from CDC that prohibits you from evicting a non-paying tenant once they've submitted this CDC declaration, it's only in effect through the end of the year, through December 31st. Now, they might very well extend this into the next year. We don't know. Frankly, it looks pretty arbitrary that they drew the line where they did. But in any event, we're kind of dealing with a short fuse here. So again, our game plan in getting this lawsuit off the ground is to file this complaint and move very quickly to try to get the court to block the rule immediately because of the irreparable harm that's being done here to landlords. I mean, for one, if you've got people who are living on your property and in violation, and not paying rent, they're taking away your ability to rent out that property to someone who actually is just as deserving of housing and who would pay rent. And so you're not going to get that money back more than likely. Probably the reason these people aren't paying rent to begin with probably is because they don't have the rent. Well, some of them are just hoarding the money they can. And then you get into questions about, actually whether you can challenge the declaration or not. I know attorneys across the country have sort of different views on that. I'm getting intel on my end, by the way, Matthew, that CDC may very well be modifying this order slightly to make clear, because there is a significant open question about whether you can actually contest the veracity of someone's statements in that declaration. They may be modifying.
What's the rumor that they're going to modify it in what way?
Modify it to make clear expressly that you can challenge the veracity, the truthfulness of the tenant in signing that declaration, because right now there's no other question on that.
If I might interrupt just for a moment. So yesterday, and one of the things in my summary of what we're going to cover today, one of the things I left out is we did have one of our, it's supposed to be monthly, meetings with the judges in St. Louis County. And one of the big questions, the biggest thing that we fought over, and it was me and Kathy Davis representing landlords, and somebody's got some feedback going on. I'm going to mute Raj. That was yours is doing feedback. So I muted you. Sorry. But one of the big things that we had representing tenants, we had Robert Swearingen from LSEM, Legal Service Eastern Missouri. We had Kalila, of course, from EHOC. We had Catholic Charities and Karen Tokars from the Washi Legal Clinic. And the big thing they were all about is you cannot challenge this. There's nothing in this. It's fact. It has to be taken by the court as fact. And you've got to go through all kinds of motion practice to get it heard. And how could you bring up facts like, questioning them about their job? This is pre-collection data that you wouldn't normally be allowed to get in discovery on a collections action. Well, sorry, they're using this to stop the eviction. So we should be able to challenge it. And this is good news. So I wish I knew it yesterday because I could have brought it up to, but I'm going to follow this up with an email to Judge Burton and that group saying, by the way, this is what we are hearing. And I'm going to let Luke.
Yeah. And I mean, hopefully, that would be helpful. Certainly it certainly doesn't take care of the problem entirely. The rule, they still don't have statutory authority for what they're doing. There's still constitutional problems with what they're doing. But at the very least, you should be able to, contest someone's declaration if you have, your blatant reason to know that it's invalid. And I know for a fact, I've talked to some landlords that they knew that their tenant lied because, for whatever reason, in some cases it's because they actually had a government assistance program talking to them and saying, I will cover this tenant's rent. All they have to do is say, yes, I want that, and I'll do it. And the tenant hasn't taken them up on that, and instead filed the CDC declaration. Said, I'm just not going to pay you. I don't know someone would do that, but they must. I don't know. But the other case that comes up, there's situations where someone has just filed this declaration, and there's good reason to think that they're lying, or not even trying to. One of the requirements is that they have to try to pay what they can. And so, most of these cases I'm talking to, once the declaration is filed, they just don't pay anything. And so, yeah, there's the possibility of challenging that. If again, the question mark has been with regard to this issue, whether you can do that without violating the order, because CDC says you cannot evict someone. If you do, you face $100,000 for an individual. They face $100,000 in criminal penalties, possible jail time as well, or $200,000 for a corporate entity and criminal penalties. And by the way, these are higher, at least death. In any event, that's the penalties that you're facing. It's very serious, and one of the reasons we think this is important to challenge. But one of the issues people are dealing with is they define eviction so broadly that arguably implicates anything that you might do to in any way contest their ability to remain in that property. So that's why a lot of the attorneys I'm talking to throughout the country tend to think, yeah, you can still challenge the declaration. But I've also talked to people who are skittish about even any communication with the tenant, let alone actually challenging their declaration. So people have different risk levels, and obviously you have to work with your attorneys and follow their best advice. So I'm not representing any of you in that. I'm just telling you what I know. But in any event, yeah. So Pacific Legal Foundation, again, our goal is to invalidate the CDC order and to do so as quickly as possible. If we are successful in getting the preliminary injunction that we're asking for, it will. There's a couple scenarios there. One is that we actually just get injunctive relief for the folks that we're representing in this case in Louisiana, and that would help, generally speaking, the landlords in Louisiana. But that would still be helpful in other jurisdictions like Missouri, because you could immediately cite to say, hey, look, this court down here in federal court in Louisiana, invalidated this whole thing.
And what's the case that's already in progress? What is their theory
They a group called NCLA brought a lawsuit, and the National Apartment Association is involved in that suit. They filed in Atlanta, where the CDC is headquartered, and they filed in Atlanta, and they are kind of a little bit out in front of us. They're going to get a decision probably on their preliminary injunction motion before ours. Nonetheless, we're pushing forward because our thought process is the more torpedoes in the water, the better. The more likely we're going to sink the ship. And yeah, I mean, they're arguing a lot of the same things that we are planning to argue, but not entirely. They've raised a couple claims that we don't think are strong.
Okay.
And we're also going to raise a couple issues that they haven't brought. So, yeah.
Okay, so thank you so much, Luke. I appreciate your time. You can hang if you want. The rest of it is all about St. Louis, and unless you are a landlord here, but hang out. Thank you so much, and please keep me up to date on it. And especially if anybody who watches this has particularly kind of egregious case where the CDC has given it to you, maybe you're managing for a small landlord like the lady in Louisiana, who's literally this is her food money. Yeah. And she's being completely stymied. Let me know. And any of these CDC declarations you get, you gotta let me know about them. Send them if there's a case in progress. If there's a case non-progress, we're saying let's hold off a bit. For the most part, they have been few, but I don't think it should stop us from filing.
Yeah, thank you, Matthew. And just I will also say that we are going to ask for, I think we're going to ask for a nationwide injunction as well as just asking for, so if we get that, then that would help everybody, definitely. But whether a court will grant a nationwide injunction is another question. And then again, we're probably going to file a second lawsuit. So I'm going to continue talking with you, Matthew, about that.
Perfect.
Yeah.
Excellent. Thanks. Thank you so much, Luke. And enjoy the California sunshine. And communists in Sacramento. Talk to you later.
Thanks. Bye.
All right, bye-bye. All right. So a second thing that we've had with excellent results so far, I'm gonna let Nick just review very briefly what he's been doing. We had good success. Some of you have been on here since the beginning. We were kind of chatting about it before we got officially started. Nick, take it over for a sec.
Yeah, so we've had pretty much 100% success on these 441 immediate evictions. Basically, we take it out of landlord-tenant court, we put it in big boy court where different rules apply, different standards apply, and the judges have a different understanding of other aspects of the law. We ask for a TRO that restrains the tenant from being physically present. This is not stopped by the CDC. This is not stopped by the judge's current orders. Both the city and county are sending sheriffs to boot people or to help them out of their units should you have grounds for one of these types of cases. Grounds fall into three categories: criminal activity. This could be drug use. This could be assault. It could be we got one lady. She walked into one of Matt's units and threatened to have COVID and said she was going to sneeze on everybody. Well, the judge found that to be enough of a threat to kick her out of the unit immediately. So you have to have some threat of violence or drug use. Damage to the property is a very common one. The law states that the damage has to be greater than 1 year's worth of rent. And if it is, then you're entitled to this eviction. The other option is the rare one, which is you have to show that they're like a threat to the employee's safety. That's tough to do, especially when you get some of the tenants that aren't even leaving their units. It's usually the drugs, it's usually the criminal activity, or the threats to other tenants. So basically what we do is we file a separate action. It moves a whole lot. That's what a tenant doing right now. We usually have these things wrapped up and have a hearing in under a week. Sometimes in the city, it takes a little bit longer to get a judge. But after that, we proceed forward. Now, Matt and I have talked about this a number of times. The TRO is only a temporary restraining order. It's only temporary in restraining them from being on the property. However, if Matt goes through and gets his judgment, which he does, then you have a permanent order saying that you're entitled to possession, and the issue is we can't kick them out because the sheriff's not going to do their job right now. With the TRO, Now the sheriff's going to come kick them out on the TRO, and now we have a legal question of do they get to come back? And Matt and I's answer to that is no. You already have a judgment for possession. The issue was getting you out. Now you're out. You don't get to come back. So, like I said, we've been having very good success with these. The city is by far, in a way, easier to work with on these, but the county is willing to do so. They're just not happy about it. And I would look for a lot of that to change after November when Judge Burton's going to apparently reconsider this order. So, other than that, that's what I got, Matt.
All right. Thank you so much. All right. So, let's update on Judge Burton. So, Judge Burton met with myself and Kathy, as I said, and the 4 tenants advocates. Judge Heggie was there, who's our regular associate judge, as well as the sheriff, Scott Kiefer. Now, I've mentioned this in meetings before. Scott is merely an employee of the county court. He is not independent as he is in the city. So he has to basically do whatever the heck the county court tells him. He didn't even speak this time. Like it's almost pointless. He nodded, when I referred to something he had said in a prior meeting. But where Judge Burton seems to be holding is he's going to do another, order, administrative order. What's it going to say? I'm not sure. I am going to update him after we're done here. I'm going to just jot myself a note, email Burton on the CDC amendment, so that according to what Luke said, the rumor is that the CDC is going to amend and allow challenge. So specifically, they did not contemplate not being able to challenge it. I can't imagine they did. Honestly, I believe it to be all political. I believe that this CDC order was Trump's way of saying, hey, I don't want anybody to be evicted. He said that. He did an executive order. The executive order had absolutely no teeth. Personally, I think it's just a way for him to do something that's distasteful to him to make sure he gets reelected. What's going to happen with the election, hell knows. We're not talking about that here today. But suffice it to say, election goes one way, we'll be getting back to normal by beginning of the year. If the election goes south, who knows? You may not be allowed to do evictions. You might not be allowed to own real estate, because you've got full-on, socialists or communists that are the most powerful people in the Democrat Party. It ain't Joe Biden. But I don't want to get too political. I've pissed people off in the past, so apologies for that. Okay, so let's talk about what the meeting said. We still don't have sheriffs open. When are they going to be open? We, meaning Kathy Davis and I, argued strenuously. Number one, you got to start letting the 441s or the unlawful detainers for any reason. Your lease is terminated. We're doing an unlawful detainer because you didn't renew your lease. Got to be able to do it. Now, one thing that came up on a case, I got contacted by a defense attorney. This is a case that came to me as they overstayed their termination. This is a one-time client. She didn't really know necessarily how these things work. But what she did was she told me the lease had terminated. They overstayed. Well, the reality was the lease had terminated, and they stayed for several months paying their rent, and then she wanted to evict. Well, if that's the case, if it becomes a month-to-month, and most of you do know this, but it's a reminder, a refresher, if it becomes a month-to-month and they do month-to-month for a bit and you agree tacitly, with that, you don't have to agree in writing. You could just agree by practice, by accepting money, and then they stay. Well, then you have to terminate them on 30 days notice like normal. You do a 30-day termination of the month-to-month. You don't have to give a reason. Month-to-month tenancy, you never have to give a reason. You do have to give 30 days. And as always with terminations, don't accept any money after you do the termination. If they do it in the night drop box, if they just throw it into your account, ignore it. If they put it in the night drop box, put it in the folder, whether it's check cash, money order, just stick it in your folder till the case is done and hold on to it. Let me know at some point. But that's where that is, okay? So the sheriffs in the city are supposedly doing the 441.
Phone cut out on the last part, man.
Yes, go ahead, Cedric. What's that?
I'm sorry, your phone cut out on the last part about if they drop it in the box or something.
Oh, sorry. If they drop it in the box, then just put it into your folder. What you don't want to do, there is case law out there that says that if you accept, quote unquote, accept money after the termination, that acceptance in effect undoes the termination. It negates the termination and starts a new rental period. So my response to that has always been, and I've actually tried this twice in front of judges. We took testimony, it never got ruled on, cases were settled. So I've never actually gotten a court ruling on such a case. We've talked about it much, but my rule for clients has always been, don't accept money after terminating, but just stick it in the folder. If they come into your office personally and say, here's our rent for this month, sorry, you were terminated, we can't accept it. They say, well, screw you, and they drop it on the desk and walk away, stick it in the folder. Same thing if they put it in your night drop box, whatever. Okay, so sheriffs are closed. We're starting now. I am starting to file sheriff's executions. So send them in. I've got a stack of executions that we've been holding on. Other attorneys are starting to file them. We're going to get them in the queue. The queue won't be that long to get through, but we're gonna start filing those. We're gonna bill you on them. You bill your tenants rather on it. As always, you know, please you know, you just have to click on the button that says request writ. Now, likewise, please, everybody who has some cases on the request execution page, and I could tell you some of those are, let's see, we've got a bunch from Andrew at STLRTO. We've got Watt Properties, we've got A&M, we've got Westport Crossing. We got a few of you. We got some from Mills. If you could go through, just click on the request writs that I have not yet processed. I'm going to process those. I'd like you to just confirm if any of those are, pardon me, no longer need, please put a message in there. I see there's a couple of messages in two of these from Winter's Warehouse. I'll look at those messages before I process anything. So go in that page and just put in a message. If they're already gone, I don't want to file, I don't want to bill you. I don't want to bill me. So we'll hold off. But for the rest of them, we're going to push them through. We have St. Charles is out there doing executions. I'm waiting for the scheduling on a bunch. I brought them on Friday. As always, we run them over the moment they're processed. Now, the ones that we're filing in the city and county are just going to sit in the queue. They're not being processed by the clerks yet. They're going to sit in the queue and wait until they reopen, until they're told to reopen. As of now, the city sheriff has given another extension. And when they did the first re-shutting down, they gave Judge Burleson, the presiding judge in the city, gave the reason, which seems sound, that the CARES Act money has not had a mechanism, an infrastructure to get delivered to people. Now that infrastructure is there. And some of the money is getting out in dribs and drabs. That's another subject of our meeting yesterday, was that we're not seeing this money actually appear. We've had one or two that actually are getting checks now. So if you are involved, and you don't always have to involve us, if people are coming to you and you don't even have a case filed, and they're doing that CARES Act mediation with you, do those mediations. But remember, very, very important, the way these CARES Act mediations work, that is one big mosquito. Missed it. The way these mediations work is the moment you cash that check, your account has to be zeroed out. It's all in the contracts that will go back and forth, but whether you're doing the mediation with us because there's a case going or separately, that's what's going on, okay? Now, as of now, I'm not charging any more to do these mediations or to, you know, there's a lot more time being spent by my office, me, my staff, to do cases now in these COVID times. I'm not changing my pricing to you guys. I don't intend to. Just send more cases. That's what makes me happy. I know that a lot of you are holding off still. You're working on deals with folks. This is not self-serving, slightly, but it's really not. The best advice I can give you is, even if you're working on a deal with them, if you think it's a little sketchy that they're not going to do it, get the case filed. It's going to be a while before we can execute on anything and everything's backed up. But if you wait until February to do it, when they screwed you on a deal 3 times, it's going to be that much longer to get them out. That's my only recommendation on that. There was an article I got, which I wanted to bring up. So there was a case, Kathy Davis actually was the attorney on a case that was appealed. They challenged the eviction moratorium. I believe it was Judge Lassiter's division in the county. They challenged the actual closure of the sheriffs, and the court denied it. The Missouri Appellate Court denied it. It's now waiting to be heard by the Missouri Supreme Court. So we'll get you more on that when we find out. My guess, it's just a guess, it may be cynical, is that the Missouri Supreme Court's either not going to hear it or just going to say affirmed. They're just not going to even give a reason. They're just going to say one line, affirmed, done. Why? Because they don't want to be the people kicking people out. Nobody is willing to be the guy that's kicking the poor people out during the pandemic. So what are you going to do? If the CDC moratorium is not extended, it ends at 12/30 on 12/31. It contemplates that all late fees, all legal fees, everything will still be owing on 12:01 a.m. on January 1st. Now, they may know that there's not going to be any collecting of that. They may not care. So in any case, that's where that stands. If it's renewed, I would say it's because the election went south. You all know what I mean by going south and what I mean by a successful election. I won't belabor the point. Other items. I think that's about it. We've had pretty good, I will tell you, we've been having excellent success in the city. We're getting judgments signed right away. They're being put of record. We're working with Judge Neal. We've never had a problem with Judge Colbert Botchway. Judge Neal was pulled out of retirement with some CARES Act money that the city got. The Missouri rule, I believe it's age 60 or 65, judges have mandatory retirement due to age. Judge Neal's spry, man. He's like super judge, very fair, and very easy to work with. County judgments. We've got a lot better response with the last docket. As you know, I've been mentioning, it's been taking 3 weeks, slightly less, to get our judgments back since we've been doing these Zoom dockets. Well, I've been complaining to hell and gone. I had a long meeting with Clerk Joan Gilmer. I've never put in complaints before to any of the clerks. I did this time, and significantly. And it's working, and we're getting better results. We're still not getting our initial court dates processed as quickly as I'd like. It's significantly behind. I sent her late last night. I was here till 2:30 a.m., normal day for me. I sent her some proof showing what's going on. Why are my cases and some of the bulk filer cases being treated disparately when some pro se people are getting processed lightning fast? They're supposed to prioritize the landlord cases, and if the clerk who's doing these divisions is not competent, get a new clerk. So, and when I spoke to her on the phone, she said, I have to look up and see if what you're telling me is true, but that's not right. So we're gonna be getting better service. Now, as far as, once they start opening the sheriff, how fast are things gonna be done? Don't expect speed right away, but I don't expect it to take months to clear the backlog. I expect it to take weeks. And then hopefully we'll be back to some semblance of normalcy early in the year. I hope by the end of January, we'll kind of be back to that 1 week from filing of writ to the sheriff on the doorstep. I'm hoping. Maybe I'm being overly optimistic. It might be end of February. I don't know. Likewise, I'm asking everybody, please, please, please be flexible on your payment terms. Now, when you give me on Ledger Update Day, and anybody I've got a humongous docket on Thursday. So everybody, please, please, please check your Ledger updates for Thursday. If you have county cases, likely you're on Thursday. The next docket after that's not till November 5th. And trust me, we have a few cases on the 15th. The rest were on November 5th because the court didn't have dockets for 2 weeks. But tomorrow's docket, please make sure your ledgers are updated early in the day today. And please put the itemized, rent is this much, late fees this much, legal this much, other utilities, et cetera. Break it down in that special instructions before court. And before that, in special instructions, if you got some belligerent jackass that you really don't want to make a deal with, write no deals for this guy, but please don't give me, got to pay in full within 10 days. That's not realistic during these times because there's no enforcement mechanism. I don't recommend it. Now, if you call me and say, listen, do what I tell you, we're going to end up with a bunch of trials. And I'm telling you, trials, they're pushing them out farther. We don't want trials right now. And this is across the board. It's not just like me because of my volume. It's all the bulk files. Everybody's getting pushed. I looked at some of the bulk filing other attorneys in Judge Lasser's division. They're getting trial dates 3 weeks after the first court date. So same thing. Now, Judge Heggie, my judge, has told me he's not opposed to me getting a second day of the week. I am pushing to be on Wednesday and Thursday in the county. And that will speed everything up. That will make everything more efficient for my benefit, of course, for your benefit. Ultimately, it's for my clients and it's for the court's benefit. The judge doesn't want these tremendous dockets. It's okay when it's a collection docket. Very few things happen on a collection docket. They get 5% of the people show up. We get 30 to 40% of the people show up, even on the Zooms. Now, in normal times, as you know, we walk out of the door with either, only a couple cases out of the 80 I might have a trial setting. The rest of them are either a default or a consent, in and out. But right now, we're not getting those consents. We have to call them after court. Now, we're putting some people into breakout rooms. I got a bunch of people going to be on the Zoom tomorrow here at my office to talk with people. Please make sure you're available if you have cases on tomorrow for a phone call to confirm how things will work out. Just please be flexible on the payment plans because it will make everything work. Now, if they say they're applying for that CARES Act money, we've got to work through that process, and that takes longer. Secondly, if they hand that CDC declaration, don't forget, you got to let me know. And if they hand that CDC declaration, we've got to put a kibosh on it. Everything's got to hold. I don't believe that that's legally correct, but for right now, we're discretion being the better part of valor. But we've had ones where people have handed in a CDC declaration. We've discussed it, but they're willing to sign a consent judgment. If they do it by consent, no problem. We're good. All right. I think I have covered. Let me make sure that I have covered everything that I wanted to. Bear with me just a moment. I'm just gonna check my my email here. So we covered the CDC, the city sheriff, extended to November 6th. So as I said, that's been extended. We've got the docket's moving more smoothly. I've covered that. And the CARES Act money, we've covered that. And this meeting will be on Facebook later. I've got it being recorded. I did not manage to get the stream working. I blame Facebook, and we'll get that rolling. Okay, questions, please, folks. The floor is open. Anybody? Bueller?
Matt, I got one for you.
Awesome. Dave?
Hey, you said we shouldn't accept payment if we've given somebody a non-renew on a month-to-month status. If we have an active judgment with them, like a consent judgment, and they pay on the consent judgment, even though we've given them notice, should we not take that as well, or is that different?
So it's kind of a gray area. What I would do is are they coming to you in person?
No, this is recent. You were just on this one this week. So
I would say if they're paying on a consent, I mean the consent judgment, does the consent judgment say a date to vacate?
No.
Okay, so I would say, the consent judgment contemplates them staying. I would not terminate them during the terms of that consent judgment because that would seemingly violate the consent judgment. So once the consent,
they've already been terminated though, prior to, and then we filed because they didn't vacate.
Okay, so I would say they didn't vacate, they terminated, but then if we did a consent judgment, that kind of contemplates them staying. I would just let them stay through the payment terms. Now,
okay.
They miss one day, you tell them, look, you're done. We're going to file the writ. If you pay me, if they come into you 4 days late with a half payment, it's supposed to be $1,000. They come into you 4 days late with $500. So listen, I'm going to give you a receipt for this, but you're going to countersign that you understand this does not change anything. You are in breach, and we expect you to move out. You still owe the money. We'll accept it. And it would be the same thing. Say there's no consent judgment. Say they've terminated, right? Now, if they come to you with money and they're willing to sign a statement that says, I understand my termination is still active and I plan to vacate at the end of the month, but I still want to pay my rent. If they're willing to sign something like that, take the money. Your termination is not ineffective. It's not been canceled because they are they're reaffirming the termination that they agree with it.
Okay, cool. Thank you.
Any other questions, please?
I have a question for you. I think Lily might have called you about this. We had another resident assault another resident.
That can't be. What happened? Hold on one second.
And the resident that got assaulted, she filed a police report, did all that fun stuff. She also filed a restraining order. So basically, do we just wait until we get the police report?
No, I would give them a 10-day notice right now.
10-day notice now? Okay.
Give them a 10-day notice. And I believe Stone Creek's leases allow for 10 days in certain circumstances.
Okay.
And everybody should always have that on their lease. That, if you have a breach, paragraphs, whatever, 6 through Z, whatever it might be, that covers all the bad stuff, not just non-payment of rent. That's not cool. I wouldn't like that in the lease, but breaching the peace of the tenants, et cetera, sell tickets and popcorn. Awesome. But if you breach these particular paragraphs, your lease can be terminated on 7 days or 10 days notice by the landlord. Serve them that, as always with terminations. Personal service, hand it to them and post it on the door. Whoever does that sometime in the next 10 days before you have to send it to me, if you do, just have them write up, title it, certificate of service. Robert did on such and such a date and time serve blank, or a resident over the age of 15 or older who does live at that house, known personally to me, with a termination of tenancy. Sign it, notarize it, have that ready. When you send the case to me, you'll send it as an unlawful detainer. You'll upload the lease, the ledger as normal. Then that third box, which we normally don't have to use for other, you're going to upload a PDF of the termination letter and a PDF of the certificate of service of the termination letter. Two things. All right?
Works for me.
All right. Other questions, comments? We didn't cover much. I'm running out of different hats to wear in these things, so I'm back to my rush hat. This is the standard. It's what I'm always gonna fall back on. Greatest band ever. I'm sorry, and I'm still mourning the loss of Neil Peart. So, we got Wayne. What's up? Do you have a question, Wayne? Wayne? He unmuted, but I don't think there's a question. Anybody else?
Hey.
Yes.
I'm Matt. I have a few questions if you don't mind. And
no problem.
So my tenant, the lease expired June. It was not renewed until now. She has not been paying.
Well,
it's been considered unlawful.
Okay, but it basically is a month-to-month tenancy because you haven't kind of evicted them earlier. I would call it a month-to-month tenancy. Give them the 30 days notice. Just assume it's a month-to-month tenancy at this point, because I would say by not taking action, sometime in July, that there's been a kind of acceptance of the default. It becomes a month-to-month tenancy. So I would give them a 30-day notice. Same thing that I just explained. You want to serve it and post it, and then write up a certificate of service, have it notarized. And by the way, if anybody needs something notarized, they don't have a notary in their office, call Courtney. She is a notary, and under the law this year, because of COVID, notaries can be done over a FaceTime. You don't have to be in person. So Wayne, do a termination of tenancy, personally hand it to them, post it on the door, 30 days. And again, you don't need to give a reason on a month-to-month tenancy. They could be terrible tenants, but we don't have to worry about proving that the reason is real. Just your month-to-month tenancy is terminated hereby. Boom. But
Is there a template or form that I can fill out? How do I do that?
Honestly, if I wasn't like so slammed, I could dictate it to you, but just generally, it could be 3 lines. Dear tenant, in reference to your lease at this address, your month-to-month tenancy is hereby terminated. Be out. Today is the 7th. Be out on November 6th at 10 a.m. Return the keys to the office. Period. You still have you could put in there also, you still have a right to be present for a move-out inspection, et cetera, et cetera. But that's it. There's no magic, and again, don't give a reason. If you're terminating a month-to-month tenancy, no reason need be given. You're best off not giving a reason. Don't say, and also, you're a dirtbag and you smell, so you don't have to do that. Why do it? Don't give more information than you have to. Okay, don't talk too much. I talk too much.
Okay, yeah, because the reason of it's I think earlier Nicholas Meter mentioned the damage of property more than a year of rent. In my case, there is damage more than that.
If it's that bad, then we have to do a 441. Then we have to do a 441. Talk to me. Not today. I would say start. I would say give them, if that's the case, give them a 10-day notice. Tell them you're causing property. This time you got to give reasons. And this is a 441. We should have done it months ago. Give them reasons. We're terminating your tenancy because you're causing all this damage. Be out in 10 days. If you want to draft the letter, send it over to me to look it over. That's fine. Okay? We'll go from there.
I can't hear you clearly. But anyway, so the damage, I'm not sure whether we can do. It's indirect because it's she didn't report the problem timely. That's caused the damage more significantly. Yeah, would that be
there ongoing damage? Is this like what Nick was talking about, where they're purposely shoving socks down the toilet, or is it just damage that's been done? If it's damage that's been done because she's an idiot and it's not ongoing, getting worse, I would do what we said. Just do the 30-day termination, honestly. It's going to be easier. It's going to be easier.
Okay. And also another question is CDC declaration, is it applicable to a property that's not on loan with any federal whatever?
Loans are no longer relevant. Loans are no longer relevant. That's not an issue.
Okay. Still, another question is, I'm sorry, currently there is a mediation. I don't know, the agency is being used for aid, is hesitating in giving money because they can only provide 3 months. Now it's over 4 or 5 months now, and she's not paying anything.
If she's not going to pay anything, you could always say, okay, I'll accept the 3 months. But you got to be really clear. If this is the same person, you want them gone, you might not be getting money from the agency.
No, the agency is not. Sounds like they are not paying as well because she is not committed in paying the rest. So that's not helping going forward.
Go through the mediation process and see how it turns out. All right.
Do I need to wait until that for filing eviction?
You could, if you're already in the process. I mean, you could always stop the mediation process, give them your kind of final thing. Listen, I need to get at least 4 months. If she's not willing to pay a single month, and you guys are going to come in with 3 months, she's not willing to pay 1 single month, what are we doing here? She's not going to be able to pay going forward, clearly. She has no money. It's just going to be the same thing happen. But you got to be willing to say, forget you. I'm not taking any money. I just want her gone. But we're still sitting on delays, sheriff's closures, etc.
Okay, but the 30-day notice you mentioned, when do I file the eviction? Is it after the 30-day notice is done?
On day 31, if they're not gone.
And then you file eviction, that's okay.
Yep. You put
I
it on-
cannot file eviction while I'm sending the termination.
Correct. Correct.
Okay,
Uh,
got you.
Any other questions?
you.
Folks? You're welcome. Any other questions?
Yeah, Matt, this is Rick.
Hey, Rick.
On this 441 evictions, what kind of documentation, for instance, on criminal activity like drug selling, what kind of documentation are they going to want
Well,
with that?
ultimately, you should have some police reports. We might even need to bring in, depending on how hard they're fighting, we might need to bring a cop in to testify.
Would a tenant do or no? If a tenant's seen the drug selling, would that help?
It might. It depends on what the judge has to say. Will it go to a trial? I don't know.
Okay.
They sometimes do, but rarely. I would just say have your ducks in a row. We need it. We have it. I would say if you can get the police reports, at least before the first court date, that'd be swell. And we'll go from there.
Okay. Another question for you. Going back to when all these people that are trying to give money out, right? All these organizations and stuff. You mentioned something about if the tenant doesn't take advantage of that when I've given it to them, that's a violation, or it helps in the process of getting them out.
Well, it's not a matter of that. It's a matter of, look, they have to proactively do this. And in
Okay.
our meeting with the county presiding judge yesterday, the advocates for the tenants are like, these people still don't know what's available to them, and they don't know anything about the CDC declaration.
Yeah.
They're trying to get us to serve with the summons a blank of the CDC declaration. I'm sorry, are we also supposed to serve them with a blank of counterclaims? Are we also supposed to serve them with a blank of 100 different legal actions they could take? Fuck them.
Yeah.
Fuck them all. They're too stupid to know what their legal rights are. They shouldn't have signed a fucking contract for $1,000 a month unit for a year. If they're too fucking stupid to sign, to know anything, to read the news, to have any idea about their rights, if they're too fucking stupid, they shouldn't be signing a $12,000 contract.
Amen.
Agreed.
It gets me a little bent out of shape. I get very angry because these racist, absolutely racist, noblesse oblige, liberal tenants advocates truly believe the people they work for are too stupid to run their own life. They are racist. They don't believe that their tenants can tie their own shoes or put on their own underwear the right way. And because of that, they are perfectly willing to tell judges that they don't know anything. I'm sorry. Ignorance is no excuse. Too fucking bad. You signed a contract. And if everybody's home watching nothing but the news and they don't know, if they don't know about the CDC thing, they clearly don't read the news. If they don't read the news, too fucking bad. I'm so sick and tired of people being treated with kid gloves. They're grown-ups. These are people in their 20s, 30s, 40s, 50s, and 60s. They were literate and smart enough and wise enough to sign a contract. But now they're too ignorant, illiterate, and stupid to know the law sufficiently that we have to give them all their defenses? Fuck that. That's my legal take on the matter. And I was much nicer and less profane in speaking to the judge, but that's pretty much what we were arguing yesterday. It is appalling. It is appalling that we should have to give our defendants the roadmap to stymie our case in advance. The obligation from the CDC is on them. That's all I'm saying. I have no strong feelings on the topic. Other questions? Anyone? All right. I think that's about it. If there's no more questions, everybody seems to have dropped off. I didn't live stream, so I'm going to go figure out how to upload this again onto Facebook. And I hope everybody.
Pleasure, Chair. Thank you.
Thank you. Thank you all for attending. And if you have any further questions, you know, you can always text me, call me. It is now 10:30 at 11. Thank you. At 11:30, I have a Warren County docket via not Zoom or WebEx, some other service that I've never heard of. So we'll see how that goes. And I hope you don't own properties in Warren County. We were continued by the court with no reason given since March or April. And this is our first hearing of these cases, all for the same property owner. So, well, at least I don't have to drive out to Warren County because that's like an hour. So in any case, thank you all.
Hey,
Don't know
Matt.
what the next meeting will be, but that's what it is. It is what it is. I will talk to you all soon. Be well.
Hey,
Yes.
Matt, I have a quick question. And so my property is for the damage. I'm trying to arrange repairs, and this tenant because she has the problems, and so she's not very
She's not letting your
cooperative.
guys in to repair.
Yeah, it's very hard to schedule and kind of thing. What do you do?
Let's talk about this. I am thoroughly slammed through tomorrow afternoon because I got a ginormous docket in the county tomorrow. Let's talk like Friday morning. Okay. I hate to put you off, but we need to spend a little.
No problem.
On this, okay.
Okay. So how do I reach you?
You have my number?
Yeah, I have your number, I think.
Yeah, just give me a call. Give me a call.
Okay.
All right.
Okay. I appreciate it. Thank you.
All right. Thank you. I'm going to end this.
Sure.
Thank you all. Take care.
Okay. Bye. Thanks.
Bye-bye.